So, my lord, and I say so candidly, in no case has there been, I mean, it may have been submitted to the court, but in no case will your lordship find a full discussion of 50. 23 and 54 have been discussed, and they do cast a shadow on 50. And there is a correction, which your lordship will see when I come. But in no case, this is the first time your lordship, and I am inviting your lordships to focus on 50 and interpret 50. That discussion your lordship will not find. But after the trilogy of cases, there have been one or two others which I need to explain. One is that Chamanmal, and the other is the Western Coalfield Judgment, which analyzes all this and deals with it. I want to argue my case without citing either India Cements or Kesara. None of your lordships hearing, but I do propose to deal with India Cements after I finish first principles analysis. Now, I had finished showing almost all the provisions, just one or two.
Even if we come to the conclusion that in paragraph 34, there is an obvious error, we are a bench of 9. So anyway, we have to...
Either way, it turns, whether there is an error, whether there is not.
We have to look at it as a matter of
first principles. And I start by saying the only real assistance your lordship...
Unless we, of course, come to the conclusion that India Cement, which is what they will argue, have been arguing, that India Cement as interpreted in Kesharam does reflect the correct position of law.
But
then to decide that, again, we have to decide it.
Again, exactly. I have to criticize Kesharam's reasoning. If your lordship say, no, I'm wrong in Kesharam and our submissions are wrong, Kesharam is right, that's the end of the matter. Right. Or vice versa. So, but this, whether Kesharam should have done this to India Cement or done that to India Cement, frankly, I don't think it's a very useful way of addressing the problem. And I start by saying, in none of these cases will your lordship find a rigorous analysis of two propositions. What really is the meaning of 50? And the different mantras, if I may borrow the Chief Justice's phrase.
Yes.
And the second your lordship will not find in any of the cases is a rigorous analysis of 49 and 50. The special excluding the general. Is it a carve out? Is it not a carve out? Everybody has said, okay, 15 of there, 49 is there. But can 49 operate on minerals in respect of 50? And the third, which needs a little clarification, the Raliaram principle, measure, was for the first time, if one may say so, contained and clarified, not in Bombay Tires, in RR Engineering. Yes. Where your lordship said, yes, but you have to remember it is only a measure, don't make it a tax. And excessive levy starts then affecting not just the measure, but it starts affecting the tax itself. That's the first time your lordship administered that caution. Bombay Tires brought it back. And there are two recent cases where Acer, your lordship struck down, saying you can't include a non-dutiable item in a measure, and how that will play out in our case. So these are the three broad areas which your lordship will have to consider, and none of this your lordship will find has been analyzed. I start by saying in the judgment in our favor, India Cement, or in Kesara, the judgment against us. So really, it's for your lordships to not consider all these aspects and come to a conclusion one way or the other. I had almost finished one or two new provisions, section 17, which only show now the overriding powers. They added now section 17, which applies to all areas which vest in the government of a state or any other person, and give the central government the power to undertake reconnaissance, prospecting and mining operations, and then they have to pay something. Details are not necessary, And my lord, since your lordships have mentioned this, I must point out, and I don't need to read the section, section 18, conservation and systematic development of minerals. Now there is an express provision. Something, my lord, which is relevant to entry 54 versus entry 23 discussion is section 20 capital A. Again, a newly added provision. This was added in 2015. Which says, notwithstanding anything contained, central government may issue such directions to the state as may be required for the conservation of mineral resources or any policy matter in the national interest and for scientific sustainable development, etc. Now, my lord, 21 has one addition. Your lordship saw 21 of the Act as originally brought in. Please see 21 now. It says, whoever contravenes the provisions of subsection 1 or 1A of 4 shall be punishable with an imprisonment which may extend to 5 years. Your lordship saw section 4(1)A at page 925, where transporting. So if you even move it without paying royalty, it is now an expressly provided for criminal offence.